Good day, everyone. I'm Arugu Speaks on Arugu Insights. Today, we will look at the meaning of a contract, and a lecture will provide an in-depth exploration of the concept of a contract, focusing on the essential elements required for a valid contract under Nigerian law. It elaborates extensively on offer, acceptance, consideration, intention to create legal relations, the capacity of the parties to contract, and then the reality of consent, drawing on Nigerian case law and English cases where Nigerian precedents are limited. Again, today's lecture will also examine the types of contracts, written, oral, and implied, and the enforceability in Nigerian jurisprudence by analyzing judicial decisions and scholarly perspectives. We will contribute to the legal scholarship on this issue by offering a robust framework for understanding contract formation in Nigeria, highlighting on the role of the judiciary in ensuring contractual integrity. Contracts form the bedrock of commercial and social interactions, establishing enforceable obligations that facilitate trust and economic stability. In Nigerian law, a contract is an agreement that is recognized as binding, imposing reciprocal legal duties on parties. Our very own Professor Ise Sage, a leading Nigerian scholar, defines a contract in his book, Nigerian Law of Contract, as an agreement which the law will enforce or recognize as affecting the legal rights and duties of the parties. Take note, this definition underscores the enforceability of agreements and their impacts on legal obligations, aligning with global contract principles reflecting Nigeria's common law heritage. If you look at our lecture on sources of law, we talked about a common law heritage and under-received English law. But this lecture will provide a comprehensive analysis of the 6 essential elements of a valid contract: offer, acceptance, consideration, intention to create legal relations, capacity, and the reality of consent, supported by an extensive review of Nigerian and English case law. This lecture will also explore the clarification of contracts into written, oral, and implied forms, emphasizing their recognition and enforceability in Nigeria. Landmark cases such as Orient Bank Nigeria PLC and Bilente International Limited, a 1997 case, will illustrate the role of the judiciary in clarifying contractual principles. The lecture will conclude by synthesizing these elements and their judicial interpretations, contributing to the discourse on contract law in Nigeria. By way of definition, what then is a contract? The concept of a contract is central to legal systems worldwide. If you go to the United States, it is central to the legal system. If you go to the EU, European Union, the contracts are cardinal to their legal systems. If you go to South America, Africa, the legal systems worldwide defining the parameters of enforceable agreements. The definition of contract by Sage, as earlier on mentioned, we said that Sage defined a contract as an agreement which the law will enforce or recognize as affecting the legal rights and duties of the parties. It emphasizes enforceability and the creation of legal obligations. This, as stated earlier, aligns with the definition of a contract by Sir John Salmon in his famous work, Jurisprudence, which he describes a contract as an agreement creating and defining obligations between the parties. The focus of Salmond on obligation creation highlights the mutual consent inherent in contractual relationship. Similarly, Sir William Anson, in his book Principles of English Law of Contract, defines a contract as a legally binding agreement between two or more persons by which rights are acquired by one or more to acts or forbearances on the part of the other or others. The definition by Anson underscores the exchange of rights and duties, a principle that is echoed in Nigerian jurisprudence by the famous Justice Nikitobi in the case Orient Bank Nigeria PLC and Bilante International Limited, where he described a contract as an agreement between two or more parties which creates reciprocal legal obligations to do or not to do particular things. These obligations collectively highlight three core components: one, agreement, enforceability, and mutual obligations. In Nigeria, contracts are governed by common law principles supplemented by statutes such as the contract law of the various states and receive English laws like the Statute of Frauds 1677. The judiciary plays a critical role in interpreting these principles, ensuring that the only agreements meeting specific criteria are enforceable. This lecture will expand on these criteria, analyzing on the essential elements of a valid contract and the application in Nigerian and English case law. What then are the essentials of a valid contract under Nigerian law? For a contract to be valid and enforceable under Nigerian law, it must satisfy 6 essential elements: offer, acceptance, consideration, intention to create legal relations, capacity of the parties to contract, and then the reality of consent. These elements ensure that agreements are legally binding, they protect the parties from unfair obligations, and provide a framework for judicial enforcement. Let us start with what an offer is. What then is an offer? According to the famous Ise Sage, a unique scholar in Nigeria, one of the best the country has produced, an offer is a clear, unequivocal expression of willingness by the offeror to be bound by specific terms upon acceptance by the offeree. It must be distinguished from invitation to treat, which merely invites negotiations, such as advertisements, price lists, or goods displayed in a shop, as decided in the famous case of Pharmaceutical Society of Great Britain and Boots Cash Chemists Southern Limited in 1953 Queen's Bench decision. An offer can express, stated in words, or implied, inferred from the conduct of the parties, and may be directed to an individual, to a group of persons, or to the world at large. In Orient Bank Nigeria PLC and Bilante International, the Nigerian Court of Appeal emphasized that an offer must be precise, communicated, and capable of creating a binding obligation upon acceptance. The Court of Appeal held that a vague offer lacks the clarity needed for mutual assent, rendering it unenforceable. This case involved a banking transaction where the defendant disputed the validity of an offer, highlighting the need for specificity in contractual terms. For instance, in Alphotrim Limited and Attorney General of the Federation, The court held that an offer to supply goods was valid only when its terms were unambiguous and communicated to the offeree. Additionally, an offer can be revoked before acceptance, provided the revocation is communicated as seen in a Folabi and Polymera Industries Nigeria Limited in 1967 decision, where the court invalidated a contract due to the offeror's timely revocation. We will now go to the second element of a contract, which is acceptance. Acceptance, according to Sage again, is the unqualified agreement to the terms of the offer communicated to the offeror in a prescribed manner. It must mirror the offer's terms exactly, and any deviation constitutes a counter-offer which rejects the original offer and creates a new one. This is a principle established in Hyde and Wrench. Acceptance must be expressed through words or implied through conduct, but silence generally does not constitute acceptance unless the party's conduct implies otherwise. In Orient Bank Nigeria again and Bilante, Achinike JCA, then in the Court of Appeal, held that acceptance must be communicated and mental assent alone is insufficient. The court emphasized that Section 109 sub 1 of the Contract Law of Anambra State requires acceptance to align with the offeror's prescribed method, ensuring clarity in contract formation. In the English case of Feldhaus and Bindley, 1862 decision reinforces this principle, holding that silence does not constitute acceptance. The assertion by the plaintiff that he would assume acceptance unless notified otherwise was invalid, as acceptance requires active communication. Nigerian courts apply this rule strictly, as seen in Okobule and Ayagbola, a 1990 decision of the Nigerian courts, where the court held that acceptance was invalid because it was not communicated in the manner prescribed by the offeror. Additionally, the postal rule, which deems acceptance effective upon posting if the post is the prescribed method, applies in Nigeria, as confirmed in Nigerian Post Authority and AB&B Limited, the 2006 decision, where a posted acceptance was binding despite the offeror's claim of non-receipt. This rule ensures certainty in commercial transactions involving what? Correspondence. We have discussed what an offer is. We have looked at what the acceptance will look like and the ways in which you can accept the contract. The third element we'll now consider is consideration. According to Ise Sage, consideration is the price or inducement for the promise, defined as something of value in the eyes of the law. It may involve a benefit to the promisee or a detriment to the promisor, and must be lawful, it must be sufficient, and must move from the promisee. In BPS Construction and Engineering Company Limited and FCDA, a 2017 decision of the Nigerian courts, the Supreme Court stated the law that consideration is the material cause of a contract, and a promise relied upon by the other party may suffice even without tangible detriment. This broadens the scope of consideration to include executory promises such as commitment to perform future acts, enhancing flexibility in contract formation. In the English case of Kure and Misa, decided in 1875, consideration is defined as some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. End of quote. Nigerian courts align with this principle as stated in Kure and Misa, recognizing both executed, that is performed, and executory promise consideration. In Akamu and Olubode, a 2001 decision, the court upheld a contract where a consideration was a promise to provide services, emphasizing that reliance on a promise constitutes valid consideration. Similarly, in SPDCN Limited and Emehuru, a 2007 decision, the Nigerian court recognized forbearance, refraining from legal action, as sufficient consideration, reinforcing the principle that consideration need not be adequate but must be what? Valuable. Exceptions such as contracts under seal do not require considerations as seen in Xenox and Wiham, a decision of the British courts in 1866. Then we'll look at the fourth, and which is a very core aspect of a contract, element of a valid contract. The parties and their intention. That is the intention to create legal relations. The parties must intend the agreement to have legal consequences. In commercial agreements, this intention is presumed unless rebutted. But in domestic or social agreements, the presumption is against legal relations, such that promises between a husband and the wife, a father and a son, a father and a daughter, a mother and a daughter, agreements of that nature are not intended to be what? Legally binding. In Enemchukwu and Okoye, the Nigerian Court of Appeal affirmed that commercial agreements carry a presumption of intention to create legal relations, and the burden lies with the party asserting otherwise to prove lack of intent. The case involved the commercial transaction where the court upheld the contract, finding no evidence to rebut the presumption. In the English case of Balfour and Balfour 1919 decision of the King's Bench, it established that domestic agreements such as between spouses typically lack intention to create legal relations unless expressly intended by the parties. The Nigerian courts adopt a similar approach as seen in Ogonyon and Ogonyon, where a family agreement was deemed not binding due to lack of intention. However, in commercial contexts, Nigerian courts are reluctant to negate intention as demonstrated in Large Group Limited and Nigerian Liquefied Natural Gas Company Limited, a 2011 decision where the court upheld a contract based on the parties' clear commercial intent. This distinction ensures that only agreements intended to create legal obligations are enforced, balancing commercial certainty with social flexibility. The next element we're going to consider is the capacity of the parties to contract. The parties must have the legal capacity to enter into a contract, excluding minors, those people or children under the age of 18, or persons of an unsound mind, and entities acting ultra vires the authority, for example, a limited liability company. In Nigeria, the Infants Relief Act of 1874, applicable in Nigeria via the received English law and the common law principles, govern capacity, allowing minors to contract for necessaries but rendering other contracts voidable or unenforceable. In BPS Construction and Engineering Company Limited and the FCDA 2027 decision of the Nigerian Supreme Court, it emphasized that a party lacking capacity cannot create enforceable obligations protecting vulnerable parties. For corporate entities, capacity is determined by the memorandum and articles of association as seen in UBN PLC and Ayodele and Sons Nigeria Limited, a 2007 decision where an ultra vires contract of the company was declared void. In the English case of Nash and Imam, the court held that a contract with a minor for non-essential goods was unenforceable as minors lack capacity except for necessaries. Similarly, in Ashbury Railway Carriage and Iron Company Limited and Ritchie, decided in 1875, a company's contract outside its object clause was void for lack of capacity. Nigerian courts apply these principles, ensuring that only parties with legal capacity form binding contracts, as reaffirmed in the Nigerian decision in Labinjo and Abake, where a minor's contract for non-necessaries was what? Declared voidable. Then we move to the final element of a valid contract in Nigeria, and that is when we'll be talking about the reality of consent. Consent must be free and voluntary, unaffected by vitiating factors such as mistake, misrepresentation, duress, undue influence, or fraud. A contract is void or voidable if consent is not genuine. In Ojo and ABT Associates Incorporated, a 2017 decision, the Nigerian Court of Appeal held that a contract entered under misrepresentation or duress is invalid, emphasizing the need for free consent. The Court of Appeal voided a contract where the plaintiff was misled about the terms, highlighting the judiciary's role in protecting genuine consent. Similarly, in Bello and the Central Bank of Nigeria, a 2012 decision, the court voided a contract due to fraudulent misrepresentation, reinforcing that consent must be free from deceit. In the English case of Candy and Lindsay, decided in 1878, illustrates that a unilateral mistake without the identity of the contracting party known to the other party renders a contract void. In contrast, in Smith and Hughes, the court in 1871 held that a unilateral mistake about the quality of goods does not void a contract unless induced by fraud. Again, the Nigerian courts apply these principles as seen in Okogbule and Oyagbola. We've talked about this case decided in 1990, where a contract was voidable due to undue influence exerted by a party in a dominant position. These cases underscore the importance of reality of consent in ensuring fair contractual dealings, protecting parties from coercion or deceit. Then we will move to something that's also very important when we talk about contracts. What are the nature of contract, types of contract? Contracts in Nigeria are classified based on their mode of formation, whether it is written, whether it's oral or implied from the consent of the parties. Each type is enforceable if the essential elements are present, reflecting the flexibility of the Nigerian contract law. What is a written contract? Written contracts are documented agreements, either simple, requiring consideration, or formal. That one will be under seal, not requiring consideration. They provide clear evidence of terms and are mandatory for certain transactions, such as real estate contracts or contracts not performable within a year. In Shana Security Company Limited and Afropark Nigeria Limited, a 2008 decision of the Supreme Court, our apex court held that the written contract's express terms are binding and courts will not imply contradictory terms. This case involved a written employment contract where the court upheld the agreed terms, emphasizing the importance of documentary evidence. The English case of Xenox and Wiham confirmed that a formal contract under seal is enforceable without consideration, provided the executor intends to be bound. In Nigeria, formal contracts are rare, but simple written contracts are common in commercial transactions, as seen in Attorney General of Rivers State and Attorney General of Bayelsa State, a 2013 decision where a written agreement was enforced based on its clear terms. Oral contracts. Oral contracts are agreements made through spoken words, enforceable if they meet all essential elements. They are common in employment, service, or informal commercial agreements, but may be harder to prove due to lack of documentation. In Union Bank of Nigeria PLC and Source, a 2012 decision, the Court of Appeal upheld an oral employment contract implying reasonable notice of termination based on conduct. The court recognized that oral agreements are valid if the intention of the parties are clear. Similarly, in Okonkwo and CCB, a 2003 decision, the court enforced an oral agreement for a loan, finding that the parties' conduct satisfied the essential elements. In the English case of Brogden and Metropolitan Railway Company, a decision passed in 1877, the court recognized an oral agreement as valid when conduct demonstrated mutual assent, a principle that has been adopted in Nigeria. Implied contracts. Contracts are implied. These arise from parties' conduct rather than express words. They are inferred in everyday transactions, such as purchasing goods or services, where actions imply agreement. In Afrap Chemical Limited and Owodoyin, a decision that was made in 2014, the Nigerian Court of Appeal implied terms into an employed contract based on custom and public policy, ensuring fair treatment. In that case, the Court of Appeal held that the employee's acceptance of work conditions implied a contract, even without express terms. Again, in UTC Nigeria PLC and Phillips decided in 2012, the court inferred an implied contract from the parties' consistent dealings, upholding its enforceability. The English case of Brogden and Metropolitan Railway we talked about earlier further illustrates that an implied contract can arise from conduct such as acting on the unsigned draft agreement. These cases demonstrate the judiciary's willingness to recognize implied contracts to ensure justice in informal transactions. The Nigerian case law on contract formation. The Nigerian courts have significantly shaped contract law, emphasizing the coexistence of all essential elements of validity. I will illustrate a few examples. In Orient Bank that we discussed earlier, Nigeria PLC and Bilante International, decided in 1997, the Court of Appeal held that a valid contract requires offer, acceptance, consideration, intention, and capacity. The court emphasized that acceptance must comply with the offeror's prescribed methods, and silence is not acceptance unless supported by conduct. This case clarified that communication of acceptance setting a precedent for contractual word clarity. Earlier on, I also talked about the Memchuku and Okoye, decided in 2017. The court affirmed the presumption of intention to create legal relations in commercial agreements, upholding a contract where all elements were present. It underscores the role of the judiciary in enforcing commercial word intent. In BP Construction and Engineering Company and the FCDA, decided in 2017, the Supreme Court emphasized the importance of capacity and consideration, recognizing that a relied upon promise can constitute valid consideration. This broad interpretation enhances contractual flexibility. Again, in Ojo and ABT Associates Incorporated, decided in 2017, the court voided a contract due to misrepresentation, highlighting the need for free consent. This case reinforces the protection of genuine consent in contract formation. In Shena Security Company Limited and Afropark Nigeria Limited, decided in 2008, the Supreme Court upheld an oral contract based on conduct, confirming the enforceability of non-written agreements. Then, in Alpha 3 Limited, the Attorney General of the Federation of Nigeria, in a 1996 case, the court held that an offer must be unambiguous and communicated, reinforcing the need for clarity in contract formation. In Okonkwo and CCB, decided in 2003, the court enforced that an oral loan agreement finding that the parties' conduct satisfied the essential elements in a contract. Now, to conclude, the essentials of a valid contract are fundamental to Nigerian contract law, ensuring that agreements are enforceable and fair. The definition of a contract as an enforceable agreement creating legal obligations provide a robust framework complemented by judicial interpretations. As we have highlighted the cases above, the Nigerian courts, supported by English precedents, where necessary, have clarified these elements, balancing commercial certainty with protection for vulnerable world parties. The recognition of written, oral, and implied contracts reflect the flexibility of Nigerian law in accommodating diverse transactions. Now, the essence of this lecture is to contribute to legal scholarship by offering just an analysis of contract formation, not too deep though, supported by case law and scholarly insights, and then highlight the pivotal role of the judiciary in upholding contractual integrity. I thank all of you for listening to us. The only way you can listen to us again is for you to subscribe to our channels. You can follow us on Arogo Insights, Twitter, Facebook, YouTube, TikTok, and Instagram. We are doing this because of you. So the only way you can encourage us to do more is to follow us and know what we are doing. Thank you.
Arugu Sights, the show that shines the light. Arugu speaks, bringing law to life tonight. From justice to judgment, every case, every sign. He's breaking it down one thought at a time. Speak, Arugu, let the people know what the law says and how it flows. From Constitution to the court's decree, he's the voice of truth and clarity. Arugu Sights, your legal guide so bright. Arugu speaks, wisdom taking flight. Tune in, learn, and stand for your right. It's Arugu Sights, where the law shines bright.